Hello everybody and welcome to the first lesson in a subject on public law. What we're going to do in this lesson is talk about the nature of public law as the subject of constitutional and administrative law itself. We'll look at the question of what it means to call something a constitution, what actually is a constitution, and then we will start to talk about the scope of this series of lessons in the future. So, like I said, we're going to talk about some of the basic features of constitutions, the idea of the UK Constitution as being a relatively unique entity within general constitutional theory and constitutional law, and then outline the basic structure of the Constitution in this series of lessons. So, let's begin. What is a constitution? That is the first question which may be asked. And ultimately, the question, simply put, is that a constitution is, in brackets, often, some document which outlines the procedural and structural components of some kind of entity. Now that sounds quite vague, that sounds quite broad, that sounds not particularly very detailed or precise, and the reason why that is the case is because a constitution does not necessarily have to refer to the constitution which governs a state, for example, like the UK Constitution. You can have a constitution within corporations. In company law, there is this idea of a company constitution, and the company constitution is the document which outlines the procedural and structural elements of a corporation, of a company. So, similarly, in this similar vein, states will have a constitution. A constitution is often a written document, and this written document outlines the basic procedural elements and structural components of the state, as well as the relationship that is had between the state and the people who live in said state. Now, the thing that is interesting about the UK's constitution is if we go back to the previous slide, I was talking here about the idea of a written document which outlines the procedural elements of a state. If we look at the US, for example, they have a single written document, and it is the US Constitution. It's not particularly long, it consists of a number of different articles, as well as 27 amendments to it. Now, that same kind of structure, that same kind of document that we have in the US is not the same as what we have in the United Kingdom. Because in the United Kingdom, we do not have a single constitution which is written down in one place. And so as a result of that, we bring us to our first distinction between different kinds of constitutions. And this is a distinction between the codified versus the uncodified constitution. Now, a codified constitution is a constitution which is written down entirely in one place. Again, I refer back to the US Constitution. It is a single document. It has a number of different articles and a number of different amendments. You can buy a copy of the US Constitution, or you can find a copy of the US Constitution online, and it looks like a document. It is a constitutional document. And so as a result of which, we call that constitution a codified constitution. On the other hand, an uncodified constitution is one which is not written down in one place. And so some people make the mistake of suggesting that the UK Constitution, because that it is uncodified, it means that we say that it is unwritten. Now, this is not actually true, and the reason why is because plenty of the UK Constitution is written. It is written down. You can find it on a piece of paper. When we look at the sources of the UK Constitution, we will note that the sources of the UK Constitution include things like parliamentary statutes, which are of course written down, or the common law, which is of course also written down. The idea here is that it is uncodified, not because it is unwritten, but because it is not written down in one place. You can't hold in your hand the UK Constitution as a single, unified, complete document. You can't do that because the UK Constitution is represented and spread across various different sources and various different historical sources, various different types of sources throughout the entire UK. And so to have the UK Constitution all in one place, you would need quite a large library in order to do so. So that's why we say that the UK Constitution is uncodified rather than unwritten. Now, in terms of the scope of this series, because it is a subject in public law, we're going to be discussing two particular topics. We're going to be talking about constitutional law, and then we're going to be talking about, briefly at least, administrative law. So that is why we're going to divide this series of lessons into two. We're going to talk about constitutional law first, and then we'll talk about the process of administrative law second. This is not going to be a series of lessons dedicated entirely to an in-depth understanding of administrative law. That is a series of lessons in and of itself. But in order to understand public law, we'll have to talk a little bit about the way in which administrative law relates to the public law environment. So the beginning of this series, we'll look at the introduction and the nature of the UK Constitution. This is going to be a particularly chunky series of lessons in the first topic. We're going to talk about what it is to call something a constitution. We'll talk about the types of constitutions, before turning our attention specifically to the UK Constitution itself, examining the UK Constitution as well as its sources. In addition to this, we're also going to talk about some of the fundamental principles of the UK Constitution. This includes things like parliamentary sovereignty, the idea of constitutional monarchy, the rule of law, the separation of powers, and this idea of quote-unquote quasi-federalism. We will then move on to looking at the various entities and institutions within the UK's constitutional framework, looking specifically at the government of the United Kingdom, the role of Parliament, the role of Westminster, the role of the executive, the role of the judiciary, as well as the role of the Crown, looking at some of the international aspects of the UK's constitutional frameworks, looking at international law, looking at the European Union, as well as the impact of Brexit and the very famous Miller cases on the Constitution. And then after that, we'll move on to talking about administrative law, beginning with the grounds for judicial review and the subject of administrative law, looking at what judicial review is, looking at the concept of illegality and ultra vires when it comes to the grounds for judicial review, irrationality, procedural impropriety, and then finally talking about the idea of remedies and administrative justice, the procedure of judicial review, limitations, role of tribunal, the ombudsman, inquiries and regulation. And then the final topic is probably going to be my favourite topic to teach in all seriousness, and this is going to talk about the relationship that is had between the state and the people. This involves looking at an introduction to human rights and civil liberties, an examination of the Human Rights Act, the European Convention on Human Rights and Fundamental Liberties, and then talking about the powers of the police as a public institution, emergency powers, and then finally finishing on public order offences and terrorism. All of those things are going to be covered in this series of lessons. In the previous lesson, what we did was introduce the subject of public law. We took an introduction to public law, sometimes described as constitutional and administrative law. And this lesson, what we're going to do is talk about the question of constitution. Talk about what it is to call something a constitution. What is a constitution specifically? Now, this is a question that we explored previously. We had a look at in the last lesson, very briefly at least. This lesson is going to be a little bit more detailed and refined in terms of coming up with some more substantive definitional requirements. So, essentially, like I said, we outlined a basic definition in the previous lesson. But this lesson is going to be a little bit more detailed. We're going to look at the nature of a constitution in more detail in this lesson, as well as look at what the subject of constitutional law actually involves, what it studies. So this question then, what is a constitution? We remember from the previous lesson that a constitution is simply some kind of entity, some kind of document, or some kind of set of rules and procedures which lays down the fundamental principles which govern some kind of organizational structure. And we noted as well from the previous lesson that the reason why this is quite a broad and quite vague definition of what a constitution entails is because of the fact that constitutions can apply to various different organizational structures. So For example, we have different areas of what a constitution, or at least different areas of study where we can find ourselves constitutions. We have the constitution of a state. You can have the constitution of an international organization. You could argue, for example, the UN Charter as being one of those, or the ICSID Convention, for example. And you also have constitutions of private organizations, so the constitutions of a company or a corporation. Now, Lord Bingham outlines what he believes to be the requirements for the existence of a constitution in the case of our Secretary of State for the Foreign and Commonwealth Affairs. This is the Clark Fishing Limited case from 2006. And in this case, he says that any constitution, whether of a state, a trade union, a college, a club, or other constitution or institution, seeks to lay down and define the main offices in which authority is vested and the powers which may be exercised or not exercised by the holders of those offices. So this brings us to further indications as to where a constitution may be able to exist. We can also think about the constitution of a trade union or a college or a club, or for those who are just starting out university, a constitution of a university society, for example. All of these things represent a constitution in that regard. And so in this definition, we can see what the purpose of a constitution is as well. We see that a constitution, seeks to lay down and define the main offices in which the authority is vested and the powers which may be exercised or potentially not exercised by the holders of those offices. And so in application of this to the state, when we're talking about constitutional law in the context of the UK's constitution, one can see the kind of things which one may study within the broader remit of constitutional law. And so this brings us to constitutional law. While constitutional law is particularly broad in terms of its study and the kind of things that are to be studied, one which does not have a specified definition either, we can see that constitutional law may address some of the following issues. Now, depending on whereabouts you go to university, or even potentially which textbook you purchase, you may get a textbook in constitutional and administrative law, or maybe a textbook in public law. They are both basically referring to the same thing. Public law often covers the Constitution and then the administrative processes that exist therein. So constitutional law seeks to address some of the following issues: the structure of government, the way in which the UK government is structured and operates, as well as the relationship between different branches of the government. The relationship between the government and the people, this includes the accountability to the people through democratic means, as well as through human rights processes. The relationship between the government and external international institutions, so the relationship between the government and the UK government, for example, and the European Union, which we were formerly a member of, or even the way in which treaty law is operationalised within the UK's constitutional framework. On the other hand, we then have, and we will turn to, administrative law in future lessons' time. Now, just like with constitutional law, administrative law is also quite a difficult subject to accurately delimit, as in to clearly cordon off what is exactly administrative law. And administrative law is similar to that of constitutional law in the sense that it also speaks about the relationship between the state and the people. And so what administrative law is often said to deal with is specific and particular functions of government, and looks to regulate numerous disputes which may be had between government institutions, so sort of intra-institutional disputes, or even between government institutions and that of the people. So the ways in which you can actually go through various judicial processes to hold the government to account for their actions. And so administrative law is very important for the purposes of, for example, judicial review, which we will get to in future lessons. In terms of finding a distinction and the similarities between these two areas of law, when it comes to broadly defining them, there are indeed distinctions which can be made. So, for example, the constitutional law, which we're going to be beginning with, looks to explain and analyse the foundations and institutional nature which will then therefore structure and govern the state itself. And then administrative law will look to check and regulate the exercise of government power. So they are broadly connected in numerous different ways, but there are also very clear, significant distinctions that can be seen with these as well. And this really brings us to the next of our questions, which is going to look a little bit at some ideas relating to the types of constitution which can exist and the principles that are codified as a result of the type of constitutions which exist as well. And this gets us into looking at some of the ideas of constitutional theory in a little bit more detail. Welcome back, everybody, to Public Law. In this lesson, what we're going to be doing is talking a little bit more about different ideas pertaining to the nature, not just of the UK Constitution, but just sort of nature of constitutional theory more generally. And this lesson is going to take a very brief introduction to constitutional theory as a topic. Now, in researching this topic, because I had never particularly taken much of an interest in or even engaged that much in ideas relating to constitutional theory in either my philosophy or law degrees, so I didn't really have that much of an engagement with it. But in researching this particular lesson, just scratching the surface at some of the topics, I'm very much interested, and it's a very, very interesting topic. So I think maybe after we've finished public law, I might do some more research into doing a particular theory, a constitutional theory set of lessons in the future. But for now, this is just going to be an introductory set of points, an introductory video. Just take a brief overview to some of the philosophical and theoretical foundations of constitutional law. Now, this is going to touch on some of the ideas that we've been looking at in jurisprudence as well. We're going to talk about positivism, we're going to talk about natural law, but we're going to talk about it through the lens of constitutional theory and the idea of the Constitution. The idea here is that we have a more foundational theoretical understanding of constitutional theory before we start to look at the framework that exists in the state in which we live, which is, of course, the United Kingdom, and the way in which the UK Constitution operates. It can also be quite useful for when we come back to and redo our lessons on the US Constitution, because, of course, they are very, very different, and different ideas of constitutional law are still bound to the same theoretical principles, some of these theoretical constitutional principles. So, like I said, we're going to be touching on three general approaches to the idea of the Constitution, focusing on one major topic within constitutional theory, this idea of constitutional legitimacy. We'll talk about the positivist interpretation of constitutional legitimacy, we'll talk about the natural law approach to constitutional legitimacy, and then we'll talk about the constitutionalism approach to constitutional legitimacy. The idea here is essentially looking at the ways in which we can understand how a constitution may be justified and the rationale behind the formation and the obligation to follow the rules that are established by a constitution. So this is really one of the most important philosophical questions, this idea about legitimacy. Why is it the case that the Constitution is accepted? And we can apply this specifically to any particular jurisdiction, or we can change one of the words and say, why is it the case that a constitution is accepted? What is it that makes a constitution legitimate? In this sense, we have to essentially ask the question as to what causes people to accept what essentially is the limitation of their power, because that's what a constitution does. It limits the power that the government can exert on the people in certain instances, and it talks about and expresses the specific regulation of the functions of government, of whether that be through checks and balances, whether that be through the separation of powers, whether that be through non-legal sources such as constitutional conventions, as we have in the United Kingdom, whether that be through specific amendments to a codified document like you have with the Bill of Rights in the United States. These are all things that limits the ability for the government to do a particular thing. It limits the ability for the government to become a totalitarian dictatorship, essentially. So what gives the Constitution that legitimacy? Why is it the case that people accept that state of affairs? Now, like I said, this is a set of questions that are far deeper than constitutional theory and can also generally relate to jurisprudential questions about law. Why is it the case that law is accepted within a society? And so as a result of this, we can actually go into the realm of jurisprudence for this lesson, and we can pick out some of the theories that we have within that particular tradition. So we can talk about, for example, natural law and positivism, which is what we're going to do now. We're going to begin with the positivist approach. So a positivist approach may suggest, as we apply this to constitutional theory, that the Constitution is legitimate on the account that we have a wide acceptance of it. So, according to Adler from 2013, for example, we may argue that a constitution is valid or legitimate if enough people whom it concerns, both officials and the public, accept it as to make it broadly effective. This is something of a consequentialist approach to constitutional theory, because it's talking about ultimately the end result of acceptance being important for the fundamental prima facie legitimacy of the system itself. So if enough people accept it, if the sort of end result, the teleology of constitutionalism, constitutional theory, is that we have a broad acceptance of these particular rules, then we can say that it becomes legitimate. So a positivist, and you could also argue even a potentially democratic approach to this idea of constitutional legitimacy, essentially allows an individual to accept that the Constitution is legitimate so long as everybody, or even a majority, or enough people within a society are accepting within its broader framework. They accept that this is the rule and regulation that we are going to follow. It's sort of a legal fiction that we all are obliged to follow as a society. It has to be effective in both the private sense as well as in the public sense. So you have officials, i.e. officials within government, they have to accept it, but it also has to be accepted by the general population, who of course have the ability to exert their democratic rights and their democratic ability to essentially change the government when they choose to, when an election takes place, for example. There may not be any underlying fact of the matter concerning its legitimacy, i.e. it may not be the case that the Constitution is legitimate because of something that is objective outside of the creation and the formation of the Constitution itself. It may just be internally legitimate on the basis of the general public acceptance of it. This is a quite interesting point, because it suggests, therefore, that the legitimacy of a constitution is essentially at the behest of the wills and the whims of the society in which we live. So it could be suggested that it is something of a subjective approach, that if society changes and perspectives within society change, then the constitutional legitimacy of a particular provision, for example, may also change. And we might see some of that when we look at some of the provisions within the United States Constitution, where you have certain provisions, certain amendments to the Constitution that seem to have effective legitimacy when the Constitution was first founded, but then as society has changed and developed over time, we see that it has essentially doesn't necessarily fit in the same kind of way. Of course, some people, including individuals who live in Great Britain, would argue that the US's Second Amendment, the right to bear arms, is something that is particularly strange as a foundational constitutional right, compared that to everywhere else in the world where the right to bear arms does not necessarily exist. And so this could also be seen as something of an argument against a codified state constitution. The idea that if a constitution is so difficult to change that society changes and leaves it behind, and the constitution sort of does not fit the broader mold of society, then this really challenges the positivist approach to legitimacy, that the Constitution may not be legitimate if the entirety of society does not accept it, but if the Constitution is codified and difficult to change, then you might be stuck with a constitution which you do not accept and which may not be legitimate in and of itself. An alternative theory is this idea of natural law. Of course, natural law posits the view that there may be some objective, external, underlying fact of the matter which can legitimize the existence of a constitution. Maybe some kind of objective moral system, an objective morality that legitimizes the existence of a constitution. So many supporters of a natural law theory, for example, may point to this idea of the rule of law, an idea that is fundamental to the UK's constitutional framework, for example, and that this encodes and enshrines very objective standards that exist. We'll get to the rule of law in future lessons' time when we look at the principles of the Constitution. But for the most part, they include things like natural justice, the right of a fair trial, the presumption of innocence, things like that. The idea that that the law is equality, that the law does not discriminate on any kind of basis, on a fundamental basis. Nobody is above the law. All of these different ideas are sort of fundamental to this broader normative framework of the rule of law. Now, on this view, we could argue, therefore, that the legitimacy of a constitution is actually contingent on its conformity to a number of fundamental principles. So rather than the legitimacy of a constitution being subjective on the basis of a societal opinion and a societal acceptance of those rules, it is actually more fundamentally objective. There are some fundamental principles by which, if the Constitution adheres to those principles, then the Constitution is legitimate. So let's say, for example, equality of law, or the rule of law, equality of law, no one is above the law, all these different ideas. These, let's say, are the fundamental objective principles by which the Constitution has to adhere to in order for it to be legitimate. And so ultimately we can then reduce those fundamental principles to the agreed principles of natural law, whatever those principles may be. Of course, people debate as to what the natural law entails. You could maybe argue that the natural law is something of a religious theory still, and argue that the fundamental principles are, for example, the principles within the Bible and the sort of moral natural law that is enshrined by biblical texts. And if the Constitution adheres to that, then therefore it is legitimate. This is something of an objective standard. And so as a result of this, constitutional theory will have a certain degree of moral authority attached to it, given the fact that natural law supports many, or at least many supporters of natural law would suggest that the principles of the natural law are in conformity with the principles of the quote-unquote moral law, an objective sense of morality. The final theory then is this idea of constitutionalism. Now, what constitutionalism is it's a movement not necessarily predicated on a desire to legitimize the existence of the Constitution, but rather it seeks to explain how the government can be legally limited in its power when it is the creator of law itself. So it doesn't necessarily concern itself with the question of what makes a constitution legitimate per se, but asks different questions. It asks the questions of, well, how can a government be legally limited in its power when it is the creator of said law? And it was a movement which came out of political liberalism and in the Enlightenment, the works of, for example, John Locke. And the general thesis of constitutionalism is this idea that the government, while they are the creators of the law, they are limited legally by the existence of this constitution itself. So from this, the authority or legitimacy of government will depend on the observation of this limitation. So we're sort of shifting the lens away from the legitimacy of the Constitution to the legitimacy of government and the extent to which government is legitimate in being able to follow its own limitations, being able to observe the limitations which are enshrined in whatever constitutional framework we're talking about. So, simply put, if the government accepts that they are limited by the Constitution from a legal perspective, then this is where their legitimacy arrives. Finally then, what is the application of constitutional theory? We've been talking quite theoretical so far within these lessons on public law. We've been talking about sort of the nature of a constitution, what a constitution is, and this lesson, of course, has been very much about constitutional theory. What is the application of constitutional theory? How do we then shift now from the theoretical into the more practical and procedural when we start to look at the UK Constitution in more detail? Well, of course, the application of constitutional theory will depend on the type of constitution, given the fact that the US, for example, is a single codified document from which all its authority derives. That therefore means that the US government can be seen as legitimate on account of its adherence to the US Constitution, which is an idea which, of course, resonates quite heavily with the idea of constitutionalism, and this idea that the government is limited very strongly by the existence of this codified document that is the US Constitution, is, of course, a very constitutionalism-esque theory. And that makes sense, given the fact that the Founding Fathers were heavily influenced by the likes of John Locke and the sort of liberal political movement that was coming out of the Enlightenment. It makes sense, therefore, that the US Constitution and ideas behind the US Constitution adhere quite significantly to this idea of constitutionalism. On the other hand, however, we have the UK Constitution, which, of course, is uncodified and derives from a number of different sources. And so it seems that the legitimacy of the government is an issue which is left more to the people and the accountability that the people have and that they can apply to the government itself. It seems that they can create more of an adherence to a positive approach to constitutional legitimacy. And so as a result of this, if we just go here, as a result of this, we find that depending on which constitution we're talking about, will depend on which kind of constitutional theory we can really explore and which constitutional theory really fits that particular framework. In this lesson, we're finally going to start to talk about the substantive procedures and structures of the UK's constitutional framework. We've been spending a lot of time talking at quite a lot of length about different ideas pertaining to constitutional theory, the idea of just the nature of a constitution in its generality, but we've spent a little bit less of time looking at the UK constitution specifically. What we're going to do is look at the UK Constitution in this lesson, but we're going to do so through the lens of the different types of constitutional frameworks that we have. And so this is going to compare and contrast constitutional frameworks from the UK system. And I find that this is a very good way of being able to understand the basics and the fundamentals of the UK's constitution. I remember all the way back doing A-level politics many, many years ago, looking at the UK's constitution and exploring it and explaining how it works by referencing and contrasting it to other types of constitutions that exist. And that's what this lesson is going to essentially do. So this is going to build on the work from the previous lesson, focusing on this idea of constitutional theory for a start, which was a very brief overview of the idea of constitutional theory, and we'll look at the different types of constitutions that may exist, and then turn our attention to the UK Constitution. So we can delineate and distinguish different types of constitutions along a number of different lines, different ways in which we can distinguish constitutions. Now, this is a non-exhaustive list of ways in which one can define and delineate and distinguish different kinds of constitutions, but for this lesson, we're going to talk about the ideas of having the codified versus the uncodified constitution, the consequences of a codified versus an uncodified constitution, looking at the distinction between a federal and a unitary constitution, and as well as that, looking at the distinction between the rigid and a flexible constitution. These are not necessarily mutually exclusive either, in the sense that you can have constitutions which will combine a number of these characteristics. We will look, for example, at the US Constitution, which is encompassing of codified federal and rigid characteristics. But you can then also maybe have a codified unitary and rigid constitution, or an uncodified unitary flexible constitution. All of these different things come together to look at the various different ways in which we can delineate types of constitution. So we know already what the distinction between the codified and the uncodified actually entails. So we have, for example, a codified constitution. A codified constitution is simply a constitution where all of the contents is written down in a single place. So a good example is the US Constitution. The US Constitution is codified because it's written down in a single unified place. I can go on Amazon right now and order myself a copy of the US Constitution. I could probably just type in US Constitution PDF and find a PDF copy of the US Constitution somewhere. If I go to the back of my US Constitutional Law textbook, you'll see, I will see, a copy of the US Constitution. This is not to be confused with written versus unwritten, because one of the things that people tend to get mixed up is when you look at a an uncodified constitution, which is just the opposite of this. It just means that it is not all written down in one place. It doesn't mean that it is not written in its entirety, because there are definitely lots of parts of the UK's constitutional framework which are written down. In fact, all of it is written down if you want to theoretically explore this. But for the most part, it's not written down in one place. Many parts may be completely unwritten, or they could just be written down but derived from a number of different sources. So when we get to the UK's constitutional sources, we will note that a lot of it is written down. For example, parliamentary statutes are written down and they are cited, and you can get a copy of a statute open. You can get a copy of, for example, the Human Rights Act. But that does not mean that they are all written down in a single place. I cannot go online and order a copy of the UK's constitution, not one that is real, at least anyway. And so as a result of this, we have to think about it from a number of different sources. Now, one of the consequences of having codified versus uncodified constitutions, specifically having codified constitutions, is this idea that you end up with what is known as principles of entrenchment and the idea of a higher law. So, essentially, a codified constitution has what is known as entrenched law. It has what is known as entrenchment. Now, what entrenchment essentially means is that when you have a codified constitution, one of the provisions within said constitution, codified constitution, will be the process by which you make an amendment to said constitution. And for the most part, codified constitutions will outline arduous and potentially difficult processes by which you can make an amendment to that constitution. So, for example, the US Constitution requires quite a lot of broad democratic support in order for an amendment to be made. So it requires, for example, a supermajority in both houses of Congress, and it also requires 3/4 of state legislatures to agree to make an amendment. This is a huge amount of support. It's a 66% of the federal legislature, and then 75% of the state legislatures have to agree to bring an amendment into practice. That's why there's only ever been 27 amendments in the entire history of the US Constitution. So what is the consequence of that? Well, it makes the US Constitution very rigid, very difficult to change. There are very few changes that ever happens to the US Constitution. You have, I believe that the 27th Amendment was in the 1990s, was when the last time we saw an amendment to the US Constitution. This is what we get when we look at the idea of entrenchment. Because it is so difficult, because the process by which you can change the US Constitution is so arduous and uncomplicated and requires so much support, we say that the law that is enshrined within the US Constitution is entrenched. It is very difficult to change. And so as a result of which, this entrenched law, this entrenched constitution, and these entrenched principles represent what is known as a higher law, as well as this, because one of the things that a codified constitution shows us is that there is a certain degree of hierarchy in terms of legal stature. So a constitutional provision is the highest of all of the different types of law that exist in the US, for example. If there is any other kind of law that is made that is in violation of or contradicts the US Constitution, then that is unconstitutional and will be struck down. All other law is subordinate to the US Constitution and the higher law. This is where the idea of judicial review within the US system actually comes about. The case of Marbury versus Madison makes this very, very clear that the Supreme Court has the ability to look at provisions that are made at a state level or a federal level within Congress, and to really compare them to the US Constitution. And where there is a contradiction, the US Constitution will always prevail. All of those things, by the way, do not exist within the UK system. There is no process that is arduous for changing the Constitution. In fact, a change of the UK Constitution can take place with a simple passage of new legislation. And there is no higher law per se, because the various sources of the Constitution sort of work and operate together. You could argue that the principle of parliamentary sovereignty implies that there is a higher law in relation to legislation compared to, for example, other like delegated legislation or even the common law. But for the most part, there is not this higher law that exists, and there is definitely not this idea of entrenchment that exists. Taking these things further then, the idea of codified versus uncodified gives us a flexible versus rigid dichotomy as well. Because codified constitutions have a certain degree of entrenchment and they are difficult to change, this means that they are very rigid. It means that they are very unlikely to ever change. The US Constitution, again, is a very good example of this. They have 27 amendments in their entire history, and the first 10 of which are the Bill of Rights, which all sort of were passed in and around the same time. And so this is actually often seen as a major critique of codified constitutions, because if it is fundamentally very, very rigid and very difficult to change a constitution, how can we argue that it reflects the ever-changing views of society? And I used this example in the previous lesson, but the example here of the US Second Amendment, the idea of gun rights within the United States, has been an incredibly vicious political issue. And it seems to be the case that there is this constitutional amendment that is difficult to change that doesn't necessarily reflect the views of society. Now, I'm not suggesting that that means that the best course of action is to just ban guns and get rid of the Second Amendment, but there have obviously been a lot of struggles when it comes to restriction of gun laws, when it comes to the freedom and the right to life of individuals who are being killed by weapons within the US, and their Second Amendment right to actually have those weapons. And there's a sort of a lot of political dialogue that is going on in that particular regard. On the other hand, though, an uncodified constitution possesses a certain amount of flexibility, owing to the fact that they are very, very easy to change. And this also represents issues, though, because it is theoretically possible for certain ideas and certain principles, which should be difficult to change, actually being relatively easy to change. The good example which we can compare is the US Bill of Rights, which is the first 10 amendments of the US Constitution, versus human rights in the United Kingdom in the Human Rights Act. Both of these things represent things that probably we can all agree on shouldn't particularly change in any regard. You should have very strong, very stable, very entrenched, codified rights for individuals. But the problem with this is the Human Rights Act is simply a piece of parliamentary legislation. If Parliament votes to repeal the Human Rights Act, they can do it at any time. They could do a vote tomorrow, and if it passes, then the Human Rights Act is gone. And so the result of which means that theoretically, the kinds of fundamental rights that you would want to be rigid within a particular system of a state are no longer so, because of the fact that we have a very flexible constitutional framework. Finally, then, you can divide the types of constitutions on the basis of their structure, in terms of the structure of the state itself. So a federal state is one which is divided, where power is divided vertically across geographical regions. A very good example of this is, of course, the United States again, which is, of course, the United States of America. It consists of 50 states, each of which have their own legislatures, they have their own Supreme Courts, they have their own judicial systems and executives, as well as that they make their own laws. And there are laws which are within the remit of the state that the federal government cannot touch, and there are laws which are in the remit of the federal government which the states cannot touch. A similar system exists in Germany. So the federal government in the United States is situated mostly in Washington, D.C. That's where Congress is, that's where the Supreme Court is, that's also where the White House is. But there are also 50 state governments, so New York State, Texas, California, etc., etc. And there are also local governments, which are governments within the 50 states themselves. And the way this works, therefore, is that power is therefore separated not only on a horizontal level between the various branches of government, between the executive, the legislature, and the judiciary, but it is also divided vertically between the federal, the state, and local government structures. And it divides power so that no one institution can become too powerful at all. On the other hand, the United Kingdom has what is known as a unitary state. This means that all the power resides in a single unified government. This is the UK's government. Now, This has been challenged in recent years. This idea of unitary versus federal within the United Kingdom, and there is this proposal by political scientists and legal theorists to propose this idea of there being not necessarily a federal state in the UK or a unitary state in the UK, but to have this idea known as quasi-federalism. And what this means is that even if the UK is on paper very, very unitary in terms of where power resides, specifically legislative power with Parliament, well, there is also the fact that there exist national governments now, owing to the fact that we have devolution. Now, we'll get to devolution in future lessons' time, but the sort of long and short of it is that devolution only exists because Westminster allows it to exist, and because of the fact that Westminster has passed legislation to allow it to exist. But for the most part, there are now various national governments. There's a Scottish Parliament, there is a Welsh Assembly, there's a Northern Ireland Assembly, and so this suggests, therefore, that they can then make their own legislation, which is now historically and generally the remit of those particular institutions. And so there are various political and technical reasons why it's not necessarily the case that we have a true federalist state. This is why we have today this idea of there being what is known as something called quasi-federalism within the UK's constitutional system.